Attorney Shedd.
Good morning. My name is Dennis Shedd, and I'm representing Edward Aduayi. Mr. Aduayi, who killed a woman with who he'd been having an affair, presented an insanity defense. The evidence of infidelity and a misleading routine instruction the judge gave, despite Aduayi's request to modify this, raised serious concerns as to whether at least two of the jurors were able to fairly evaluate the evidence and apply the law. Now, the judge gave the then model instruction that if Aduayi were found not guilty by reason of insanity, or NGI, the court may order him to be hospitalized for 40 days of observation. During that period, the DA may file a petition for a commitment. If the court then found him mentally ill and dangerous, he may be committed for a 6-month period, and any commitment would then be periodically reviewed. Now, during the charge conference and during the jury instructions, after the instructions, Aduayi objected that the reference to the time periods and the suggestion that the entire process was discretionary falsely suggested that a defendant found NGI might be held for only a short period or not at all. And the judge acknowledged the validity of that concern. He stated, "I grant you those time periods might suggest to someone that one is only briefly detained, but very few people are so briefly detained. But I'm very worried about not instructing the jurors accurately about the law." And that's in volume 16, page 148. Now, the judges committed prejudicial error by not modifying the instruction to address Aduayi's concerns. Long before trial, this court had stated the purpose of the Mutina instruction is to allay concerns that a defendant found NGI might go free. And the court had also stated that the instruction did not need to mention the time periods. Shortly after trial, Chappell established a new provisional instruction. 2018, the court established a new model instruction that specifically addressed the concerns that Aduayi raised. The reference to the observation period has been eliminated. The jury is told that the DA generally does file a commitment petition, and if those conditions are satisfied, commitment is mandatory, not discretionary.
Mr. Shedd, how have we handled this post-Mutina, post-Chappell issue? I know we had the Dunn case where the objection wasn't raised, as is pointed out, but have we had other post-Chappell cases before us?
Well, if I'm hearing right, you asked about the cases after this where the court has said that after this instruction was accurate and its use was an error.
Yeah,
Okay.
Right, after Chappell.
Okay, I've got just 2 points I'd like to make about that. First is that, first, the instruction is not accurate. The instruction informed the jury that commitment of a person deemed mentally ill and dangerous was discretionary. Such a person might not be held. But the statute, Chapter 123, Section 16, says that that's mandatory. So that error in the instruction right away completely undermines the purpose of giving the Mutina instruction, because it says a defendant may go free if found NGI. Secondly, putting aside that issue, there are two distinctions between this case and Dunn and other cases in which the court has said the use of that instruction was proper. First, in all but one of those cases, there was no objection to the instruction. And second, as far as I can tell, in none of those cases was there evidence that a seated juror had expressed concern about how long a defendant found NGI might be held. And that did happen in this case. During the voir dire, Juror 5 asked the judge if there's a chance that a defendant found NGI might be released within 3 years. Judge said probably not, and I'd give an instruction on consequences at the end. The judge then asked the juror if he'd be able to follow the instructions regarding the Commonwealth's burden of proving criminal responsibility. The juror said yes. Questioned by defense counsel, the juror said he felt that somebody found NGI of murder should not be able to re-enter society for a long time, if ever. So what happened here is what the judge told the juror during voir dire implied that the instruction he was going to give would allay the juror's concerns about how long Aduayi might be held if found NGI. And that would have been the case if he'd modified the instruction as Aduayi requested. But the instruction the judge gave suggested that exactly what that juror was concerned about might come to pass.
But along those lines, the juror says to the judge, to just say it in a different way, that he could be indifferent. And then, on a follow-up voir dire from defense counsel, he gives his own personal view.
That's right.
His own personal view, the attorney for the defendant could have considered that on a peremptory, but his own personal view doesn't matter. Everyone has views of the world. The issue is whether or not he could be indifferent, and he told the judge he could.
Well, I think what happened here is that after the judge says, I'm going to give a defendant found NGI, probably won't be released within 3 years. I'm going to instruct you on the consequences at the end. I think the implication there was that my instruction is going to allay your concerns. And with that as the setting, he then he tells defense counsel, that I think somebody should be held, shouldn't be able to re-enter society for a long time, if at all. But that his response to the judge saying, yes, I'll be able to follow the law, is in the context of this implication that the instruction is going to allay these concerns. And in fact, the instruction did just the opposite. It just played into those concerns by saying, this person might be released in a short time. So because the jurors were misinformed about the consequences of an NGI verdict, one can't be sure that this juror...
Mr. Shedd, have we had cases in the past where we take what happens during attorney voir dire on issues raised and then use that for the prejudicial error analysis thereafter?
Yeah, I believe that has happened in other cases. But, the attorney conducted voir dire certainly raised concerns here. After the judge, the juror first says, I've got a problem, is this going to be, might he be released in a short time? The judge says, I'm going to give this instruction, and the attorney comes back, and it really heightens this concern that this juror is worried about how long Mr. Aduayi might be held if he's found NGI. And the instruction did nothing to allay the concern, and that was the entire purpose of requiring an instruction on consequences in the first place.
I guess that leads to your first premise in that the Mutina instruction is legally wrong.
Right.
Correct?
Right.
Have we said that, or have we said the opposite? I know in Chappelle it said we don't like it and we need to change it, but have we ever said that the Mutina instruction, as provided in this case, is legally wrong?
No. The court has never said that, no. No, the court has said the instruction was accurate in other cases. That's certainly the case. That's what the court has said. But my argument here is that by it saying that a defendant found mentally ill and dangerous may be committed when the statute makes it mandatory shows that, in fact, the instruction is wrong. It's inaccurate. It doesn't comply with the statute. Okay. Unless there are any other questions about that issue, I'd like to turn...
I have one related question just to the insanity defense. In a nutshell, as short as you can make it, what is the best case for your client on the insanity defense?
On the insanity defense? So you're talking about it besides this consequences issue?
Yeah.
Yeah, the insanity defense
I want to know, what was the evidence you see in the case that would have pointed to a possible NGI?
Sure, there was evidence that he suffered from depression. There was a period he was in Nigeria. He was suffered from depression for a period of time there. His family reported incidents of rather odd behavior, him talking to himself, going off the handle at odd times for no reason before this happened. He was treated throughout the period he was jailed before trial by a psychiatrist. He reported consistently primarily audio hallucinations, some also visual hallucinations. He reported he's been having them for years and years and years. Hallucinations sometimes telling him to go out and kill people. And then two of the psychiatrists who treated him testified about they thought, yes, he was in fact mentally ill. He was being treated with antipsychotic drugs and another drug for depression.
Did they testify that he met the standard, the legal psychological standard for an NGI?
No, they did not. So the evidence at trial is basically on history of mental illness, his reports of hallucinations, and what can only be described as the rather bizarre nature of the crime.
Okay.
There was no testimony at trial by a psychiatrist or a psychologist saying, yes, he meets the definition of insanity. Okay. So moving to the next issue. During the voir dire, juror number 2, the foreperson, stated that evidence of infidelity could prevent him from being impartial, because he believed that people who do that are beyond the law, that they can get away with things more than others. Now, that was his last word on the topic. There was no challenge, but the seating of a biased juror violated Mr. Aduayi's rights to an impartial jury and created a substantial likelihood of a miscarriage of justice in this case. Studies have long showed that many, perhaps most people, are skeptical of the insanity defense, thinking that it's an excuse that defendants use to try to get away with crime.
Did the defendant have any peremptories left?
Yes, he did.
And he didn't challenge the juror?
He did not challenge the
So
juror.
what do we do with that?
Well, that's why I'm arguing it's a substantial likelihood of miscarriage of justice standard, Your Honor. So that's...
Have we ever done that, though? Have we ever said that when there's an opportunity for a peremptory challenge and there's no challenge to the juror, that in a non-murder it's a substantial risk, or in a murder, substantial likelihood?
There was an appeals court case I cited where that happened. If I got the note right, if I have the note right here on that, I do not. There was an appeals court where they had a similar situation. They handled it on a substantial risk standard. That's cited in my brief. And so in this case, I'm arguing it's a murder case. I'm arguing substantial likelihood.
Didn't the juror ultimately say that he could be impartial?
I'm sorry, I couldn't hear
I'm
that.
sorry, didn't the juror ultimately say during the voir dire that he could be impartial?
He did, yeah, in response to the judge, he did say, the judge asked him, basically, putting that aside, are you going to be able to follow the law regarding the Commonwealth's burden of proving criminal responsibility? To that, the juror responded yes.
That might be why the defense attorney didn't challenge, correct?
Well, what happened after that, he said that at that point, and then the defense counsel questioned after that, and he went back to this concern the juror had raised. He said, you refer to character traits, what are you referring to? And that's when the juror said, I think people who do that feel that they're beyond the law, that they can get away with things more than others. And the defense attorney then asked, could that prevent you from being impartial? And the jury said, yes, it could prevent me from being impartial. And
Was there anything past that? Did the judge clean it up or anything?
it didn't get taken up after that, and there was no challenge for cause. So that's why I'm here arguing substantial likelihood, Your Honor. So again, so this juror did say, in response to the judge, yes, I can follow the law, but what he's told defense counsel kind of backtracks on that, but there was no challenge. So this is a jury who believed that Mr. Aduayi was a person who felt he was beyond the law, that he could get away with things more than others. A person with that belief would be bound to be skeptical of any defense Mr. Aduayi raised, and that's particularly true of a defense that many people are skeptical of in any event. And it also makes him particularly, so it's likely that he would have suspected that Mr. Aduayi may well be using this defense as a loophole, as an excuse to get away with murder. It also made him somewhat predisposed to accept the testimony of the Commonwealth's expert, who stated that he believed that Mr. Aduayi's reports of hallucinations were false. So in this case, it's my position that the seating of Juror 2 violated Mr. Aduayi's rights to an impartial jury and created a substantial likelihood.
And how should we view the defense attorney's failure to strike this juror through a peremptory?
All I can say is, I mean, I spoke to him about that, and at the time he had no memory of why that happened. I did note that in
Well, what do you think our legal analysis of that should be? Like, how does that factor into our legal analysis?
Well, it certainly, I mean, I think primarily it changed the standard of review. Obviously, if he objected, we'd be here on a different standard of review. And also, if he'd used a peremptory, it'd be a different standard of review.
Well, he might not,
that's why it's
yeah,
substantial likelihood here. I think that's how it plays into the analysis. Okay, now turning to the redacted interview issue. The Commonwealth concedes that because of the way this interview was redacted, the jury heard Mr. Aduayi say that he wanted Ms. Sanders to stab herself, to kill herself, when in fact what he said was he wanted to end their affair. Now, that misleading impression would not have been established if either Mr. Aduayi's answers, "that's what I wanted," had also been redacted, or if the questions that preceded those answers had been included pursuant to the rule of verbal completeness. Now, the Commonwealth argument is that there's no harm done here because during most of the interview, Mr. Aduayi said that Ms. Sanders had stabbed herself, and only at the end did he admit that he had stabbed her.
Right.
And so it claims that the misleading evidence they heard is simply cumulative of this earlier false statements. But what the jury...
I forget, can you just refresh my memory? How many times was she stabbed?
I'm sorry, I didn't...
How many times was she stabbed?
She was stabbed numerous times. I think it might be more than 30. It was numerous. She was stabbed numerous times. So...
I'm not sure how this factors in if ultimately he admitted to having killed the victim.
I'm sorry, I can't...
I'm so sorry.
It's,
Yeah, help me understand how the interview piece where it sounded like he might have said, I wanted her to kill herself. How does that factor in if he ultimately admitted to having killed her and he was going for an NGI?
Okay, yeah. So what, the point, so let me just backtrack a second here, so to put it in context. So what the jury heard him say here isn't just one more time that she stabbed herself. What they hear him say is, that's what I wanted to happen. In other words, they heard him say that he wanted her to die, which is compelling, and he never said that at any point during the interview, in fact. So that's first, it's compelling evidence he had the malice necessary for murder. And second, because he said, after he admitted he'd stabbed her, he said several times, I didn't intend to kill her. So that's also strong evidence suggesting that he understood the wrongfulness of his conduct, if you put that in context. And that's how it plays into the insanity defense. So this misleading redaction created a substantial likelihood of a miscarriage of justice by, one, creating strong evidence of the malice for murder, and also undermining, on the other hand, undermining the insanity defense. Now, I've got, unless there are other questions on that, I've got a minute left. Mr. Aduayi wanted me to point out, at page 11 of the Commonwealth's brief, it implies that there were no completed phone calls between the two of them that morning. It says that shows between 10:33 a.m. and 12:34, the defendant attempted to call the victim 8 times, but she missed the calls. In fact, exhibits 107 to 109 showed that he answered calls from her at 11:04 and 11:22, and she responded to the call from him at 12:34. So there were 3 completed calls that morning. So in this case, because the jury was misinformed that a defendant found NGI deemed mentally ill and dangerous might nevertheless not be committed, because the foreperson of the jury believed that the evidence of infidelity could prevent him from being impartial, and because the jury heard false evidence that Mr. Aduayi wanted Ms. Sanders to die, he should be granted a new trial.
Oh, thank you. Okay, Mr. McGee.
Good morning, Chief Justice Budd, members of the Supreme Judicial Court. May it please the Court. My name is Michael McGee. I'm here on behalf of the Commonwealth. I ask the Court to affirm the conviction of Mr. Aduayi for the brutal murder of 28-year-old Carnitha Sanders. The defendant raises 3 issues on appeal. The first one was waived. The second one was about a piece of evidence that was put in by agreement. And the third is about an issue that has been decided 5 times since this trial and found to not have been error. This was a case where the defendant here stabbed the victim 49 times. He was found in his underpants at the foot of a stairwell by the police with the victim behind him dismembered in a bucket. He attempted to mislead the police for 2.5 hours of an interview to suggest that she stabbed herself, that she somehow wanted to be cremated if she had committed suicide, and then finally, at the end of the interview, admitted that he killed her, yet he did it in self-defense. This is a case where the issue of criminal responsibility was fully before the court, before the jury. The defendant here participated in a day as he normally would, driving his son to work, going to work himself, Mr. Aduayi. He even later that day picked his sons up at the train station, helped them build a lawnmower, all while he had the deceased victim deceased, and then goes to Walmart and picks up a meat cleaver. And all of this was before the jury. All of this was discussed by the Commonwealth's expert in rebuttal to the criminal responsibility defense, and the conviction of first-degree murder here was right and appropriate, and I'd ask you, Your Honors to affirm that conviction. Starting with the issue that the defendant raised at the start of this on the Mutina instruction, I would suggest to the court that the Odgren case is a good one to look at. It was the fifth of those 5 cases that have since come out since this case was decided by the jury. In that case, defense counsel raised it at trial, asked for an instruction regarding the continuity of someone that's found not guilty of commitment for someone that's found not guilty by reason of insanity. And over their objection was given the then model instruction, a Mutina instruction. Additionally, in reviewing the appellate brief in that, the attorneys for Odgren also raised the issue that during voir dire, many of the jurors had raised the idea that someone can be set free for having committed a crime of that nature by reason of insanity. So that issue was fully before the court, and this court in 2019 found the issue that the defendant raises today to be meritless. I'd ask Your Honors to find the same today. Also, on the point of that defense counsel raises about the issue of permissiveness of a judicial finding in a commitment hearing, it is accurate. And what I would suggest to the court that contemplates is that it is quite a process annually for a person to be committed involuntarily in a mental health court, whereby there are reports submitted by a treatment team, and the hospital or the district attorney's office has to prove beyond a reasonable doubt that a mental illness exists, that there's a nexus between that and the substantial likelihood of a risk of harm to himself or herself or others, and that there's no less restrictive alternative. And after all of that, and that burden is met, a judge must make that finding. And I would suggest that that is an accurate statement of law, and that this court has, again, stated that 5 times. Going to the first, unless there are any questions, and I apologize, Your Honors, are there any questions on?
No.
On the first issue that defense counsel raises, I would suggest that it is waived. This is a situation where it was, I believe, the 5th prospective juror, and there were peremptory challenges available and for cause.
And so what's the effect of waiver in this case? What do we do with we say, oh, it's waived. What's our next step?
Well, I would suggest that there is no, as counsel raises, no risk of, well, there's no error here, and I would suggest this is somebody that, a juror that brought his feelings, his attitudes, his opinions to the concern of the court, as he should have.
So suppose we say, okay, there's no error, but maybe we say there is error. If there is error, what effect does the waiver have on our analysis?
The effect is that because it wasn't waived, there cannot be a risk of a miscarriage of justice here, because there was no motion for new trial. There was no ineffective issue raised here. We don't know why, or we weren't there. We don't know the demeanor of this juror, his candor towards the court, and we don't understand if there was any strategy involved here. I can also tell you that there was a jury later in the panel that also raised the issue of it was juror number 42. Said that she was divorced because her ex-husband was unfaithful. She was struck not because of that, but because she had a pending OUI. So taken into that consideration, as well as the overwhelming evidence here, this was a brutal horror scene of a crime where the defendant was caught red-handed. And as to consciousness of guilt, like certainly overwhelming here. He's caught with the receipt for Walmart for the cleaver. He tries to mislead the police for 2.5 hours, only to admit and then minimize his conduct. While he's in jail, he asked one of the clinicians how someone's supposed to be mentally ill here. All of that was before the jury here, and taking that as a totality, I would suggest that there was no risk or a miscarriage of justice. And just on the final point about the agreed upon transcript that was submitted to the jury by identification here, as has been said in my brief, this was 2.5 hours, had gone through an interview here, and because of a redaction, I would suggest it was an unresponsive statement to a question resulting from this redaction. And really what the trooper was getting at there is how incredible this story was, that she had somehow committed suicide. And the trooper was pressing the defendant about that. You ask, you expect me to believe that she somehow killed herself? And then there's this response that is difficult to hear. That's what I wanted. Taken in the totality of that interview, it was it didn't factor into this at all. And what did factor into it, this trial, was that for 2.5 hours he stood by that story, that he tried to mislead police and held up their investigation, and then finally, at the end, admitted that he killed her, and that he certainly didn't dismember her because it was her wishes. Again, I'd ask the court to affirm the conviction of the defendant for this brutal homicide of Kernitha Sanders. And unless there are any questions, I'd rest on my brief.
Thank you very much.
Thank you very much.